today. We're pleased to have the people from Tar Heel Challenge. I always enjoy seeing that group here. We have Maxim Medina. Where are my pages? I saw them come in.
In the back.
In the back.
To the left there.
Okay. If you'll stand up, pages, when I call your name. Maxim Medina. Dennis Pagoada Valdez. Okay. Jasmine 2. And Jason Ventura Cruz. I hope I didn't butcher your names too badly, but thank you for joining us today. And members, I told you we're going to have a tough day. I'm going to start with House Bill 813, and there's a PCS, and without objection, the PCS is before us. This is the Pretrial Integrity Act. Representative Bradford, you are recognized to present your bill.
Thank you, Madam Chair.
PCS.
Okay, thank you, Madam Chair and members of the committee. I want to thank Representative Hall, or Chairman Hall, and also Representative Jones. Neither of them could be here, but I asked them to be on the bill because we all know Rep. Jones used to be a judge, and of course Representative Hall is an attorney. But this is the Pretrial Integrity Act. It does a couple of things. This bill was actually brought to me by some folks back that I work with, Police Chief Johnny Jennings out of Charlotte, my district attorney Spencer Merriweather out of Mecklenburg County, hoteliers. But it does a variety of things. It expands the list of serious felonies for which a judge can determine release conditions. Also expands the list of serious felonies for which a judge could refuse release conditions for a defendant. Requires release conditions to be set by a judge versus a magistrate, extends intervals between custody review. I have heard of zero opposition. I'll duck, but so far I haven't. But my door is open, as I always try to run my legislation. And there will be a friendly amendment, I think, before we get to rules. It won't be here because it's not ready. But I'm happy to run that amendment and rules when we get there. So I would ask for a favorable report. Thanks.
All right, members of the committee, we're open for discussion or questions. If not, Representative Morey.
Thank you very much, Madam Chair. Representative Bradford, what is the need for this bill? What isn't working by setting bonds on anything but capital trials, by having juveniles come in 10 days instead of 30 days? And especially I'm concerned about the part, if anyone is out on pretrial for a charge and gets a new charge, they could be held 48 hours from the time of the arrest without bond. What is the problem we're trying to solve?
Well, I mean, and there's a couple, but I would just point to, there's been a few instances where magistrates have actually let folks be released where it should have probably gone to a judge, and the judge may have ruled differently. So I think it's more about accountability and making sure that judges have those decisions. You know, I just think for my area, we have some very specific examples, and I don't know if we have anyone here from the audience to speak, but where someone was arrested, a magistrate let them go within 30 minutes, and then they went and committed another heinous crime, and the thinking is if that would have gone to a judge because of the class of felony, then they wouldn't have got out right away. So it's really just trying to tighten things up to make it a little more accountable and safer. That's really what I think the intent of the bill, which is why it was brought to me.
Thank you. Follow up.
Representative Moore, you're recognized.
I appreciate it. And just for a comment to that, we always take a few incidents that are bad, but then we try and make it a law that applies to everyone. And if that magistrate made an error in setting a low bond for a person to get out, that magistrate made an error. But for us to ignore innocence until proven guilty, to give bonds or lack of bonds, violates my thinking the right of the Constitution, a right to bail. Magistrates, judges can set $1 million bail if it's a serious offense. The second one is if you're out on pretrial release on a traffic offense and you get in a car and you commit another traffic offense, you can now be held without the right of bond for 48 hours. I don't think our jails have the capacity for that. I think it's denying constitutional rights to people, and I would encourage us not to have a favorable report on this. Thank you.
Madam Chair, yeah, so, thank you for those comments. I would just say that when I have a district attorney from Mecklenburg County, one of the largest counties in the states, coming and asking for some help here, I have a police chief, Johnny Jennings from Charlotte, asking for this. I have a lot of other organizations. No one has come to me to oppose this bill whatsoever. Representative Moore, you're the first comments I've heard otherwise. I would just tell you that we need to move this bill. I would ask this committee for a favorable report. And Representative Moore, hey, happy to listen to any concerns you have, but I don't think there's anything wrong with trying to create more accountability in our judiciary system, and that's really what this bill intends to do. So thank you for your comments, but I would ask the committee to give a favorable report. Thanks.
Okay. We have further discussion and further debate, and again, I think I've heard Representative Bradford say he's willing to continue to see if there's some additional thing and maybe share some examples with you if that's what you need. Representative Butler.
Yeah, what's the proposed amendment, Representative Bradford?
Well, so it's not ready yet, but the proposed amendment, give me 1 second. It came from pretrial services. I hate to talk about amendment before it's ready, but it's just a couple things.
I won't hold you to it.
I'm sorry?
I won't hold you to it.
That's fine. Yeah, it's adding pretrial services, and it talks about there's a risk assessment that Mecklenburg does. Not all counties do a risk assessment, but it would be, if that risk assessment is available, that's something that could be used, and a few other things that all sides seem to be supportive of. And it came from, I think, the pretrial group or association or something. That's how it came to me.
Just one quick comment.
Yes.
I would agree with Representative Moore. I mean, we have a presumption of innocence in this country, and the philosophy behind our entire judiciary of criminal law, to my knowledge, is that we would prefer one guilty person, go free than others who are innocent be in prison. And to hold somebody for 48 hours without bond is enough time to lose your children, if you have any, even if you're a juvenile. Some juveniles have children, to lose your job. I just feel like also, as she suggested, that this is a circumstance where having the correct bond in place is enough. So I can't support the bill.
Thank you. Representative Green.
Just a motion when appropriate.
Further question or comment? I don't have the comment list. Is anyone back there scheduled to speak on House Bill 813? Oh, you've given it to Lisa.
Madam Chair.
Yes, sir.
I am Spencer Merriweather. I'm the elected district attorney from Mecklenburg County. I'm grateful to Representative Bradford as well as Representative Jones and Representative Hall for agreeing to sponsor this bill. I come on behalf not only of the people of my district, but also the Conference of District Attorneys, but also all of the crime victims that I heard from just last week, who literally have seen decision after decision come from our magistrates and say, why wasn't I heard on this? Why didn't anybody hear from me? Because those folks were released before there was a decision that was actually made in open court. What this bill does is actually meet the expectations that most of the general public already thinks happens in the justice system until something happens to them. And so we want an opportunity to make sure that people who have committed these crimes, first violent crimes, have an opportunity to go before a judge, and that judicial discretion is protected within the law. We also want to make sure that people who are already on pretrial release, who then have committed another crime, that again, that judicial discretion is protected, that in open court, victims have an opportunity to be heard, and judges have an opportunity to hear everything that they need to hear. With regard to the particular aspect about how it affects juveniles, this is specified for Class A felonies for folks 16 and 17 who need to be heard from, but we don't have to make the families that have suffered from a homicide come to court every 10 days, merely to come every 30. Because we realize that lightens their load. That would be our ask, and I appreciate the consideration from this committee.
Thank you. And I didn't specify, but we should limit public comment to 2 minutes, staff, because we have so much to do. And that brings me to my other point with the committee. Any bill that doesn't get concluded today will be heard tomorrow at our regular meeting. So hold on to your paperwork so we don't have to copy it again. I see that Jessica Smith has asked to speak. Ms. Smith, you'll be given 2 minutes, and you have the floor. She's going around.
Good morning. To be clear, I'm here on request. The School of Government is non-advocacy, so any comments that I'm going to offer you are not here to argue for or against the bill or any provision of it, but just to provide you some information that can help you in your exercise of your policymaking authority. The one provision of the bill creates essentially a preventative detention statute. It gives the judge the authority, the discretion to say no bail. And it gets at a core problem with our bail system, which is that sometimes really dangerous people can buy their way out of jail with no supervision. In this respect, the thing I wanted to bring to your attention is that the United States Supreme Court has indicated that for a preventative detention statute to be constitutional, it must include certain procedural protections. The court decided a case called Salerno, where it upheld the Federal Bail Act, which allowed for preventative detention precisely because that statute contained a basket of procedural protections. The protections the court identified specifically include things like a full-blown detention hearing, with the defendant having the right to counsel, to present evidence, to cross-examine witnesses, for there to be an individual determination with factors identified by the statute, for there to be a standard of proof. In that case, it was clear and convincing evidence. And for those reasons, the court held that the federal bail statute passed constitutional muster. This is an issue that I've written about. I have a guide for policymaking if anyone is interested in looking at those protections and how they could be incorporated. I have that for your availability. The other thing I'd mention is on the 48-hour hold, most charges in North Carolina are for nonviolent misdemeanors. In 2021, there were 1.3 million charges, 1.2 million were misdemeanors, and 1 million were nonviolent. Most pretrial crime is also misdemeanor offenses, and also even within felony offenses is nonviolent. I present that information to you solely to think about some unintended consequences by having a provision that doesn't limit the 48-hour hold to, for example, people charged with serious offenses and committing new serious offenses. Thank you.
Thank you. And we also have, for 2 minutes, Johnny Jennings.
Thank you, Madam Chair. This is Chief Jennings with the Charlotte-Mecklenburg Police Department. I want to thank you for the opportunity to talk, but first of all, I want to say that we need help. We have to be advocates for our victims. When you have an assault, I can give you examples all day long of cases where we haven't done that for our victims. When you have a young child who is sexually assaulted and the suspect who gets out in 37 minutes does not do any justice to our victims. And we have to have some more integrity when it comes to pretrial bond issues and who we're letting back on the streets. We're not denying bond for anyone. We're just doing much like we have with the domestic violence cases, to where you have to go before a judge in order to get that bond. And when you go before a judge, the accountability to our people is much greater when it's put into the hands of a judge and not just a magistrate. We're not talking about all crimes. We're talking about the most serious violent offenses that deserve, if you've developed probable cause on an individual for those offenses, it deserves to be seen before a judge. And if you commit another crime, and we're not talking about a traffic citation, you're likely not going to jail for that. If you go back to jail, then that would mean that you're going to have to go before a judge for accountability purposes also. So I'm begging you for help for our victims. This is not something that's just for police department or the district attorney's office. We need to be more accountable to the people that we're sworn to protect and serve, and to ensure that our most violent offenders are not back on the streets in 37 minutes for doing a heinous crime or a heinous act, allegedly, that we've developed a probable cause for. Thank you.
Thank you. Members of the committee, further discussion, further debate. I think that's all I had seen signed up for 813. Have I missed someone?
No, Madam Chair. My name is Liz Barber at the ACLU of North Carolina, and Representative Bradford said that no one was opposed, and I just wanted to be clear that the ACLU of North Carolina is opposed, and I didn't sign up for comments, and so I will refrain from.
Madam Chair.
Thank you.
Yeah, for clarity, what I said was I don't know of anyone who's opposed because no one has approached me, including the ACLU.
All right.
Thank you.
Thank you.
Further committee discussion. Representative Willis.
I'd just like to echo Chief Jennings' comments on this. You know, we fed one of the divisions in Charlotte-Mecklenburg last week, and, you know, I heard from officer after officer the issues that we're having, especially with some of our juveniles on this. And you know, we've got to have better protections, better support for our victims out there. So I just echo his comments, and thank you.
Representative Morey.
Thank you. Just to comment a second time, I have the same concerns for our victims. And I think any magistrate that would set a bond on a serious offense and get out in 37 minutes, the problem is with that magistrate. We're not focusing on the problem here. We're creating a solution that is too broad, over-encompassing, does not meet federal guidelines and standards of a real hearing if you're denying bond, and I think it's unconstitutional. Let's address bonds with magistrates. Let's teach them. Let's keep victims safe, but this bill is not the way to do it. Thank you.
Representative Green, you're recognized for a motion.
This is a PCS, is that right? Okay. Madam Chairman, I'd like to move for a favorable report to the PCS for House Bill 813, unfavorable to the original with a referral to rules.
I will. You've heard the motion. Those in favor will say aye.
Aye.
Those opposed will say no. In the opinion of the chair, the ayes have it. The ayes do have it, and the bill will be reported favorably to rules.
Thank you, Madam Chair.
House Bill 22 has been removed from today's calendar. We have, and I'm trying to get the members who are not members of the committee and who have the most people wanting to speak. We have House Bill 691, Representative Cleveland, on new resident temporary concealed carry permit. Representative Cleveland, you are recognized.
Thank you, Madam Chairman. House Bill 691 will allow a sheriff to issue a temporary handgun concealed permit to a new resident of North Carolina if the person possesses a current, unexpired, out-of-state permit and meets the following conditions. The person's out-of-state permit will expire within 120 days of establishing residency, and the person submits all required application materials except for the certificate of completion of an approved course for a concealed carry permit. The temporary permit will be valid until the person submits the original certificate of completion from an approved course and the sheriff grants or denies the application, or the person does not submit the original certificate of completion for an approved course within 120 days of the issuance of the temporary permit.
Questions, comments from the committee? Representative Butler.
Thank you, Madam Chair. I just wanted to thank Representative Cleveland for coming to discuss this bill with me briefly this morning. We're just going to disagree on some things, aren't we, Representative Cleveland? But I will say this. I just feel like if someone comes into this jurisdiction, they should follow our rules. And I know Representative says that they will do that, but, you know, you can do a lot of damage in 120 days. And I just feel like someone who is a responsible gun owner understands that going through North Carolina laws and processes is not too much a price to pay to ensure the safety of the public. So I think that, again, 120 days is not too long to wait for something as important as a concealed carry permit. Thank you.
Other members of the committee? Representative Willis.
I'd like to speak on the bill. I think, you know, the safety that we're talking about on here isn't the safety of the general public. The safety of the person that's moving in is paramount at that point. If they've been approved by another state on this, they should be approved by ours as well, unless there's something within that background check, and we're giving them the grace period to be able to do that. I'd ask you to support this bill. Thank you.
Further discussion or debate by the committee? Seeing none. Representative Smith, you're recognized for a motion, and this is a PCS.
Gotcha. Madam Chair, I move for a favorable report to the PCS of House Bill 691, unfavorable to the original with the serial referral to rules.
You've heard the motion. All those in favor will say aye. Aye. Those opposed will say no. The ayes appear to have it. The ayes do have it, and the bill will be so reported.
Thank you, Madam Chair. Thank you, committee.
Representative Pirtle. And then I'm going to bring your people. you're recognized to bring forth House Bill 707, which I believe is still the original bill, and there is no amendment.
Thank you, Madam Chair. Yes, I'm withdrawing the amendment that was presented. We're going to try that again. House Bill 707 is entitled Assault on First Responders and Social Workers. In the summer of 2002, during a 3-week period, 6 law enforcement officers were shot, 2 of them fatally wounded. And it's kind of ironic, I was in my last committee meeting and my phone went off, and I was missing the 38th annual Peace Officer Memorial Ceremony today in Raleigh. But this bill does basically 3 things. First, it increases the punishment for anyone who commits an assault with a firearm upon any of the following persons who are in the performance of their duty. The bill would increase the punishment from a Class D felony, which is 24 months, to a Class B1 felony, which is life without parole. Persons included in this is a law enforcement officer, a probation officer, parole officer, a member of the North Carolina National Guard, an employee of the detention facility operated under the jurisdiction of the state or local government, an emergency medical technician or other emergency health care provider, a medical responder, and a firefighter. Second, it would increase the punishment for assaulting an executive officer, a legislative officer, or a court officer inflicting serious bodily injury. Currently, there is no distinction between assaulting and inflicting serious bodily injury between that of a legislative officer, executive officer, or court officer and the general public. However, it is a difference in the statute if there is not an infliction of serious bodily injury. So I've just removed that and increased that from a class from an F to a Class E. And then finally, the bill would change the definition under 14-16.101 that defines a court officer. The new language would include an attorney or other individual employed or acting on behalf of the county and the Department of Social Services as defined by 108A-24. We've had some issues with some of our social service workers being assaulted and having to find an appropriate charge to charge the individual that did assault them. It's my hope that once this legislation passes, that in every social services department across our state, there will be clear verbiage listed that if you assault one of these workers out there doing the work of the community, that you will be held accountable. I've had a lot of questions about why I feel that this bill is important, especially the assault on the law enforcement officer. There's no secret that I spent 30 years in law enforcement. And when it comes to assaulting law enforcement with a firearm, I just don't think that your marksmanship should impact your punishment, should in any way mitigate your punishment just because you missed. I've been to officers' funerals. My co-sponsors on this bill, I want to thank those. Between us all, I was adding it up, we have over 120 years of law enforcement experience. And I'm sure my colleagues that are on this bill with me have shared those same sentiments of going to a funeral and shaking the hand of a widow. Marksmanship shouldn't impact this punishment. I'll stand for any questions.
Members of the committee, questions, discussion, debate? Seeing none, and I don't see anyone signed up to speak on 707, Representative Miller, you're recognized for a motion.
Thank you, Madam Chair. I just want to thank Representative Pirtle, and like he said, we have over 120 years in this room of law enforcement experience. And just last week, a Columbus County officer pulled into a domestic call, and started taking fire, and his vehicle was shot up, and thank goodness nobody was hurt. So with that, I would move for a favorable
inquiry of the chair. I'm sorry, Madam Chair.
Smith?
Was there an amendment to this?
There was an amendment. It's been pulled.
Oh, I'm sorry.
So we are on the original bill.
Can I continue now?
You may continue.
I am sorry, Mr. Vice Chair.
Yes, thank you. Would like to move for a favorable report of House Bill 707 and refer to rules.
All those in favor will say aye. Aye. Opposed, no. The ayes have it. The bill will be so reported. Next, we're going to take up House Bill 189, which we have the most speakers here on. And staff, I advise that, Sergeant Arms, I advise that if there's anybody who stepped out, that they would be allowed to come back in for the presentation of this bill. I'm hoping everybody's been able to get in. I will limit speakers. I'm trying to get 3 pro and 3 con, and limit to 1 minute so we can hopefully get this bill passed. But I know there were a lot of people from out of town and out of area, that people that are not regularly here, so we want to try to give them the respect of hearing this bill. We have a PCS, and it's on North Carolina Constitutional Carry, House Bill 189. Representative Kidwell, Representative Adams, Moss, and Pless are the primaries on this bill. Representative Kidwell, and if we can be as quickly as possible so we can get this moving.
I could just go with it's a very short, non-controversial bill, but I don't think that'll fly. Good morning, ladies and gentlemen, committee members. Thank you for hearing this bill. North Carolina Constitutional Carry Act, we would be the 28th state to enact constitutional carry, so it's not something new. Across those states, we've not seen a increase in crime due to the constitutional carry, so I want to allay the fears of that. There's been some questions I'm going to address right up front, concerns over allowing 18-year-olds to do it. The Ninth Circuit Court of Appeals in Chavez versus Boutro said that you cannot use the age of 21, that 18 would be the legal age for that type of a restriction. I've received 1 email and 1 person who has spoken to me in the negative against hundreds of emails and in-person visits who have been in the positive for this bill. I will stand for any questions.
Would you like to send forth your amendment, which I understand is primarily technical in nature? Would you like to send that forward?
Yes, thank you, Madam Chair. We can do the amendment now. It's quite simple. It actually is eliminating what I'm going to call a 404 error. If you click that link, it doesn't actually attach to a law. This was an error, clerical error, so that just removes that site.
And then it changes a pagination from C to a B.
Correct.
So we have the amendment before us. Any comment or discussion on the amendment? Seeing none, the question before the House is the passage. The question before the body is the passage of the amendment to House Bill 189. Those in favor will say aye. Aye. Those opposed will say no. The ayes have it, and the bill is amended. We're back on the bill as amended. We'll have committee discussion. Members, anyone? Representative Budd.
Yes, thank you, Representative Kidwell. I will comment first that while you have received 1 email in opposition and hundreds in favor, I am the opposite. I have received hundreds in opposition and almost none in favor of the bill. But I have one very simple question. In your first section here, you have a number of weapons that would be unlawful to carry concealed, such as knives, dirks, daggers, brass knuckles, and the like. But yet you've exempted firearms. Why are you exempting the lesser lethal weapons from this carrying concealed bill that you are proposing?
One reason would be that's a battle to be fought another day. The second reason is those are currently in law. And at this point, I don't have the requests from my local people, constituents that are interested in moving those.
Further discussion? You have a further question?
I hear you, but my question is, the most lethal weapon is the firearm. It is the only one that you are seeking to exempt from being carrying concealed.
So
Representative Kidwell, you're recognized.
Thank you, Madam Chair. First of all, the Second Amendment does actually cite all weapons, that it does not limit it. So knives, it would be appropriate. But in this case, and what I'm looking at, is firearms are a defensive weapon. Okay, these are not going to be an offensive weapon. These are defensive weapons. I am going to need this in the event that somebody comes after me with a knife, gun, dirk, shank, whatever the case might be.
Further question, further discussion. Representative Morey.
Thank you, Representative Kidwell. I think your bill goes a lot further and broader than what has been presented. It looks as though anyone 18 or older can carry concealed without ever having firearms training. There's no permit that's needed at all. They would just have the right to carry concealed. And in any assembly where a fee is charged for admission or where alcohol is served, as long as the person doesn't have alcohol in their body, and any government official who is elected or appointed when acting in the discharge of their official duties, they may carry concealed, which I take it are legislatures, judges, anyone in jails, any public buildings. If they're acting in their official capacity, they can be carrying concealed. Is that correct?
Well, let's start. You actually have several questions in there, so let's start with the education element and the 18-year element. In my comments up front, the Ninth Circuit Court of Appeals said that you could not limit to 21 years old. It had to be 18, so that's been struck down. That's why the 18. The second question was the education element. They do have an education requirement. If you do not receive the appropriate education, it would be a misdemeanor, and you would have to deal with that. So you do have an education requirement to carry concealed at any age. The carrying for legislatures, you would still, or elected officials, you would still have to have a concealed carry permit in order to carry a firearm. It would not be where you could carry it as the average citizen could, around their home, out in the neighborhood, that type of thing. So if a legislator wanted to come in this building or any other building, or a judge, well, judges are currently permitted to carry. So there's a list, if you look, where judges, I think DAs may be on that list, registers of deeds, things of that nature, they are allowed to carry in the government buildings currently.
Right.
This would just add other elected officials to that. You may note we've had some events that happened in the General Assembly in the last 2 years where many of us, and I say us, have received death threats. In fact, we have one person who recently received many a death threat, and she's applied for a concealed carry permit and is being tied up in her local sheriff's department for not a good reason, and she has received many death threats. Okay, so we need to look at it from the perspective of freedom, and I'll go back to the basics of where this all begins. Both the North Carolina and U.S. Constitution cite the rights of the people to keep and bear arms shall not be infringed.
Further comment?
You're recognized for comment.
And I think the Constitution also has something about a well-regulated militia. This may be about the right to carry and freedom to carry, but it's not about public safety. And I think you mentioned that states that have the right to constitutionally carry have less violence, which I don't think is accurate. I think that it's proven that the states with the most restrictive gun laws have the least amount of gun crime. The availability of guns everywhere, anytime.
You will be. Everybody will be quiet and be responsible in this meeting, please. If not, you will be asked to leave.
Representative Maury, that's absolutely incorrect. Okay.
I don't believe, Representative Kidwell. There's simply a comment, not a question.
Thank you, ma'am.
Representative Maury, are you through with your comment?
No.
All right, you may finish your comment.
Thank you. In this country, in this time, public opinion is demanding we do something to protect people from mass shootings, from gun violence. This bill is the opposite of what people are demanding. I think it is ill-conceived. I think we should vote against it. And I also take issue of the 18-year-old being unconstitutional to have it 21 instead of 18. I think that's an issue that's still in the courts. So I strongly urge us to vote against this bill. Thank you.
I'm going to go to public comment, and because of the number of people wanting to comment, I'm going to limit it to 1 minute. I'm also only going to take, I think it's 3 or 4 on each side, and I'm going down the list. First on the, I believe, pro side is Paul Valone. You have 1 minute.
My name is Paul Valone. I represent Grassroots North Carolina, the state's primary gun rights organization. 27 states have adopted some form of constitutional carry without any of the problems being predicted by our opposition. The fact is that this is a relatively modest bite at the apple because it basically limits the concealed carry without a permit to the same class of people who can get a permit. If you couldn't qualify for a permit, you won't be able to carry concealed. Also, the PCS has a training requirement to it that allows at least some measure of education. This is a very modest bill. Grassroots North Carolina strongly urges you to support it.
Thank you. I believe Jennifer Copeland, I believe you are opposed to the bill. You have 1 minute.
Thank you. Jennifer Copeland, North Carolina Council of Churches, representing 18 member denominations in North Carolina all across the state. We consider this bill a threat to public safety. We believe that if we weaken laws on who, how, and where we are allowed to carry guns, we will ensure that more people carry guns and more guns will get stolen, particularly from motor vehicles and also likely from homes, and they will be used in crimes. With respect to Representative Kidwell, I would say follow the numbers. In states that weakened concealed carry laws, gun thefts increased by 35%, adding tens of thousands of guns to the streets and illegal gun markets each year. Not surprisingly, gun-related crime increased in those places by 29%. Closer to home, 1,000 guns were reported stolen from vehicles to the Charlotte-Mecklenburg Police Department last year. Not surprising, violent crime in Charlotte increased. The Council of Churches believes lawmakers have a moral obligation to protect the people of North Carolina, and this bill will not do that. Please vote no. Thank you.
Andy Stevens.
Good morning. My name is Andy Stevens. I represent Gun Owners of America. I am the North Carolina State Director. Gun Owners of America supports this bill as currently in PCS. I would make clear to the committee that this does not eliminate the concealed handgun permit statute that currently exists in North Carolina. Over 860,000 North Carolinians have a concealed carry permit. This bill will not kill that opportunity and requirement to get a permit issued. For reciprocity and other purposes, it remains in place for citizens to be able to travel across state lines. This will alleviate a problem that exists in several counties, including Mecklenburg County, where the sheriff has been slow walking permits. At one point, he had 7,300 permits that he was delaying or denying the issue of a shall issue permit to lawful citizens in Mecklenburg County. Again, I request that the committee, on behalf of Gun Owners of America, support this bill. Thank you.
Thank you. Shannon Halber. Ms. Halber, you have 1 minute. So we plan to take a vote at 10 till, so we'll be limiting some discussion beyond this. You have the floor for 1 minute.
My name is Shannon Halber. I've been a volunteer with Moms Demand Action for Gun Sense in America for 8 years. I'm a U.S. Air Force veteran, and I live in Clayton, North Carolina. I'm here today to oppose North Carolina House Bill 189. It does not keep our community safe. States that have weakened their firearm permitting system have experienced 11% increase in handgun homicide rates, 13 to 15% increase in violent crime rates. 18 to 20-year-olds commit gun homicides at triple the rate of adults 21 years and older. Suicide risk can increase when the gun violence already costs North Carolina $19.5 billion each year. Every year in North Carolina, 1,588 people die by guns and another 3,530 are wounded. What is the cost going to be if this bill becomes law? Thank you.
Marie Evett, Sheriff Association.
Thank you, Marie Evett, Sheriff's Association. We ask you to oppose this bill. Right now, sheriffs can make sure that people who are carrying concealed weapons know the law, have a minimum level of accuracy. They run mental health checks, and they make sure that they don't have any types of criminal histories that would prohibit them from carrying a concealed weapon. This bill would still allow, or would allow folks themselves to determine whether they're capable of carrying a concealed weapon. And sheriffs now have professionally trained staff who have difficulty determining that sometimes. So to be in compliance with the law, we're expecting the citizens to be able to figure that out themselves, and in some circumstances that's going to be very difficult for them. Practically, this bill would make it nearly impossible for law enforcement to know when they approach someone whether they qualify as someone who can carry concealed. Right now, they have the background checks. They know that before the permit is issued. If this bill passes, they will not know that. And so every citizen they encounter, they'll have to determine whether that citizen should or should not be carrying a concealed weapon. So we'd ask you to oppose this bill.
Thank you. And a final pro speaker, Becky Ciertas. Have I got the name? Have I butchered the name completely? You have 1 minute.
Yeah. Okay. My name is Becky Kirchdas. I'm the Executive Director of North Carolinians Against Gun Violence. Repealing our concealed carry weapons permitting system is a dangerous idea because it would allow people as young as 18 years old with no training and no background check to carry a hidden loaded weapon. Who can be against training and background checks? Permitless carry puts the general public and law enforcement at a greater risk of their lives. In addition, people with criminal convictions are trying to get guns, but background checks are stopping them. We need to strengthen our permitting system overall by providing local sheriffs' offices with the resources they need to process permits in a timely manner. 81% of U.S. adults opposed laws allowing concealed carry without a licensing agreement. I urge you to stand with law enforcement and the general public and vote no on House Bill 189. Thank you.
Members, we are right at the time to take a vote. So I know that there are more things that want to be said by lots of people, but I will entertain a motion at this point.
Madam Speaker, I had a couple of concerns about this bill early on, but I appreciate the sponsors working in a duty to disclose provision in there. I think that's important for law enforcement. I hope as we go forward we can put in some provision about the enforceability of the training measure. But that being said, I'll make a motion for a favorable report on the PCS to House Bill.
The PCS as amended.
House Bill 189 with a referral to rules.
Unfavorable to the original.
Unfavorable to the original.
I'll get you trained eventually.
Madam Chair.
You've heard the motion. Representative Maury? I'm sorry.
I'd like to ask for the ayes and noes on this vote, please.
That's what I was going to ask. Thank you.
Haven't seen it sustained. So, yeah, those in favor will say aye.
Madam Chair, that's in the case of division, as I understand it, not in the case of the ayes and noes.
If you're okay with suspending the rule that we have to vote by 10 till, we will call for the ayes and noes.
I'm fair.
Just long enough to take the ayes and noes.
Yes, ma'am.
Okay. Madam Clerk, you'll call the roll.
Representative Budd? No. Representative Budd? No. Representative Butler? No. Representative Butler? No. Representative Gill? No. Representative Gill? No. Representative Green? Yes. Representative Green? Yes. Representative Maury?
No.
Representative Maury? No. Representative Pirtle?
Yes.
Representative Pirtle? Yes. Representative Smith? Aye. Representative Smith? Yes. Representative Willis? Yes. Representative Willis? Yes.
Okay, you're next.
You want to go?
Ms. Pirtle? Yes.
I did it. Representative Hall?
Aye.
Representative Hall? Yes.
We're done. We have no time.
Do you want to vote?
I don't have to.
Okay.
You're
done.
Did you call Miller?
Representative Miller?
Aye.
Representative Miller? Yes. Got it.
1, 2, 3, 4, 5, 6, 7. 1, 2, 3, 4. Vote 7-4. Bill passes and will be reported to rules. Remember to keep your papers because we will go over these other 4 bills as well as everything else on the calendar. You've done a great job, committee. We were sort of shorted to 10 minutes because of delay getting in here, but hopefully we won't have that problem tomorrow. And thank you. We are adjourned.